Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas are admonished to draw near and give their attention, for the court is now sitting. May God save the state of Texas in this honorable court.
Thank you. Please be seated. Good afternoon and welcome to this special session of the Supreme Court of Texas. With the 6 arguments the court will hear this week while in Houston, we will have completed our tour of all the cities in the state of Texas that have accredited law schools, and will have thus fulfilled the first round of our power to visit various locations in the state that the people granted us by constitutional amendment in 1997. Today at the University of Houston, how much trouble am I in? Today at
This is Monday.
This is Monday, and we're at South Texas College of Law, and we're very pleased to hear 3 cases, which we will hear in 2 oral arguments, the second 2 having been consolidated. In the first cause, we will hear the Honorable Lee P. Brown, Mayor, and the City of Houston versus Rob Todd and Steve Hotze, a case that originates out of Harris County. And we will then take a brief recess, and the second argument will be 2 causes. Gary Lawrence and his wife, Marty Lawrence, versus CDB Services Incorporated from Potter County, and Danny Lee Lambert and Teresa Lambert, individually and as next friends of Rusty and Rebecca Lambert, versus Affiliated Foods Incorporated from Randall County. In these 2 arguments, the court has allotted 20 minutes for each side to present argument. The petitioner can reserve a portion of that time for rebuttal by advising the marshal of our court. These arguments are being videotaped and audio taped. This gets a little complicated. You can purchase an audio tape of either or both arguments by making application with the clerk of our court in Austin, and there are a limited number of videotapes available for sale, hopefully not including my first slip, and you get those from South Texas. Justice Abbott is voluntarily recused in the first cause, but he will join us and hear the second argument after our recess. We are now ready to hear argument from petitioner in Brown versus Todd.
May it please the court, Ms. Judy Hatfield will present argument for the petitioners. Petitioners have reserved 8 minutes for rebuttal.
Good morning. Good afternoon. I too am nervous this afternoon. Thank this court for agreeing to hear arguments in this case. This is a very important precedent for this state, I think, the issues presented today. I had the first opportunity of observing arguments before this court when you visited UT about 10 days ago. So I'm aware that this court likes to go directly to questions. To comport with that, I hope the court will allow me to make a brief 2-minute opening, and then I will do my best to answer your questions. This court should reverse the Court of Appeals decision as to Todd's claim of lawmaker standing for 2 reasons. First, Todd has presented no right controversy for judicial review. Instead, he seeks judicial resolution of a political issue before the normal political process, through in this event, the legislative process, has had the opportunity to resolve the conflict. Secondly, Todd's claim that the executive order deprived him of the loss of the right to vote on the subject matter of the order alleges only, quote, an abstract dilution of institutional legislative power, unquote, that does not give rise to an injury specific enough to confer standing.
So you're taking the position now that this controversy is not yet ripe?
That's correct. As part of this, it's subsumed in the issue of standing.
Why is it not right?
It's not right because the Councilmember Todd has not proposed an ordinance that would contravene the mayor's executive order. He alleges in his complaint that the mayor has usurped his council's authority to legislate on the subject matter. In truth, he's not even attempted to assert his legislative power to propose an ordinance on the subject matter, nor has City Council as a whole voted on that matter. Because
If what the mayor has done is illegal or not authorized by statute or the city charter, who would have standing to challenge that as a practical matter?
As a practical matter, any private litigant who is subject to the terms of the executive order, in this particular case, any employee of the city of Houston is subject to that executive order. So any employee other than an elected official. So any employee subject to discipline under the executive order or threatened with discipline under the executive order has the right to challenge the mayor's authority to have promulgated that order. This court will have full opportunity, or a lower court will have full opportunity, to reach the merits of this case when there is a right and justiciable controversy brought by a private litigant.
So you say only employees of the city would have standing?
Under the terms of the executive order, as Todd has asserted them, yes, I think an employee of the city of Houston would have that right, and only an employee.
The order is pretty broad. It covers all city activities, doesn't it?
That's true, it does.
If the Boy Scouts wanted to get a permit from the city to use a park, and they were denied, would they have standing to challenge that?
They might at that point have standing, but that would be a legitimate controversy where they've done an affirmative action that has requested a city facility and been denied a city facility. In that case, there might be a specialized concrete controversy for this court to resolve. At this point, there has not been one.
It doesn't strike you as odd that a janitor could bring the suit, but not a member of the city council?
No, that doesn't strike me as odd, because a member of city council, council as a whole, could file this suit if council as a whole had attempted to contravene the terms of the executive order or pass an ordinance that happens to affirm the executive order. Until and unless council has done that, Todd, as a member of council, has only one vote on council. Under the Rains v. Byrd
You
analysis...
think if the council defeated an ordinance, then Todd could bring suit?
No, I don't believe so either.
So what's to keep the mayor and the council from conspiring to violate the organic documents of the city?
A person with right justiciable controversy, like an employee, or like in Justice Gonzalez's scenario, a Boy Scout group who had applied and was denied a permit for a city facility.
So no harm, no foul, no matter how egregious the governing officials may violate the organic documents of the city.
That's the constitutional limits of separation of powers on standing. The constitutional limits in both federal and, as you know well, in our state Supreme Court has said that those are limited, that the injury must not be to either the voters as a whole, the people of the state as a whole, or legislators as a whole. It must be a specialized, concrete injury sufficient to confer standing. Unless and until that has occurred, this matter is not right in the sense that rightness is part of the subject matter justiciability requirement.
Most of your cases, maybe all of them, are federal cases where you're dealing with three co-equal branches and asking one branch to resolve a dispute between the other two. That's not quite the situation here with the city, which both branches of which are wholly a creation of the legislature.
That is true. That is a distinction. But what I am asking this court to do is apply the principles that are enunciated in Rains v. Byrd. And
But why
besides,
should we do that?
we should do this because your own opinion in Texas Association of Business requires a concrete and specialized injury. The bottom line here is there's not yet been a concrete and specialized
Would
injury.
Todd ever have a concrete injury if the dispute became right? Would it be possible for him as a councilman?
Not as a single council member. My position is that city council as a whole might have a concrete and specialized injury. If, for instance, city council passed an ordinance that in effect negates the executive order.
What if Todd had been joined by a majority of councilmen or council members and challenged this with absent an ordinance? Would they have standing?
Not absent an ordinance, I believe.
Why is that?
Well, because there would not be a concrete controversy. You must, or the legislators must, attempt to exercise their adequate political remedies first. If in failing to do that, what they're asking this court to do is exercise judicial refereeship of a political issue before they've even attempted to fight the
Why
fight.
can't they simply seek a declaration that what the mayor has done is outside the bounds of the charter?
Simply because there's no concrete controversy, and city council can't do that until and unless it has asserted its own authority, which it has not yet done.
But Raines says that's okay, it's just not the law of the United States. It's okay to get in the middle of political controversies, and courts in other countries do. What's wrong with it? And courts in other states do. New York, for example. So why not here?
Because the Texas courts have always said that there is no concrete specialized injury if it's just a complaint that there has been a violation of the law. The cases on taxpayer standing and on voter standing in the state of Texas comport with this view.
When you say that the council must exercise their own authority first, is that based on what?
Well, based on Todd's allegation of this complaint, I certainly do not
But when
agree.
you say that they have to do that first, that they must, for example, try to act as a body first, why should we agree with you on that point?
You should
Why?
agree with me because unless they do, there is no concrete injury. There's no actual controversy for this court to resolve. If they had done so, if council had passed an ordinance that in effect contravenes the executive order, and if the mayor had continued to assert the validity of his executive order, and a majority of council brought this suit or authorized Todd to bring this suit, then we would have an actual controversy for this court to resolve.
What would happen if the city council say, this activity is put as an agenda matter on the council's business, and the council, majority of the council say, we're not going to adopt that as an ordinance for the city. We reject that adoption as an ordinance of the city. And then the executive decides, well, legislatively, we can't win on it, but I'll just impose an executive order. Now, is it your argument that the council, having rejected it once, must now come back and countermand the executive's decision in order to make it ripe for there to be a concrete injury? Or are you saying that before Todd can come here, he has to get a vote from the majority of the council authorizing Todd to represent the council? What is it? What is the concrete injury you're talking about that Todd has to suffer?
If council did indeed consider such an ordinance and did contravene the ordinance by refusing to enact what the mayor has done by executive order, for instance, if that had come before council and council had defeated it, they may indeed, at that point, have a specific injury sufficient to confer
Have
standing.
they been injured any more than they have been by not being allowed to vote on something that they think they're
Well,
supposed to vote on?
I certainly don't concede that they would have an injury, but I could see that it's a closer question, more arguable that they might have standing.
Why would you draw the line there? If your line has been, we have to have somebody who actually has harm to their
Well, council would have...
pocketbook, as it were, rather than just to their pride.
I hate arguing the other side's case, but I think at that point, they would then argue that council has been harmed as a body.
But how is that any less political or any more particularized than this?
It is more concrete.
Well,
And
you
it is-
say, but how?
Well, because they would then have exhausted their political remedies. The fact that alternate...
Well, no, they could go beat the governor in the next race. And that's one of the possibilities.
Well, that's true. That's true. They could.
So then why is it more particular? If they still have that remedy left, why do you think they should get to sue in those circumstances?
Well, I don't concede that they do, but for sake of argument, it would be a closer question. But I do not concede that they would have standing, to be clear.
And on the closer question, it wouldn't make any difference whether the ordinance had been rejected years ago or whether the ordinance was rejected the day before the executive imposed it by an executive order.
If you're going to the Hotze question, yes. In my argument about Hotze's standing is that 85 referendum was fully completed and his votes were fully effective back in 1985, and that as a public policy matter, this court should not extend the Bloom decision to cover further than an election that was held 15 years earlier. If it does...
6 months later?
Well, 6 months later might be a closer question.
Why?
Again, the closer in time that you go to the vote, the closer the argument becomes that there is a concrete injury.
Where would you draw the line?
Well, I believe it would be up to you to draw that line.
Where would you draw the line?
Where I would draw the line is arbitrarily at some point within, I would say 6 months is probably reasonable to claim standing on that basis. But beyond that, you get into the generalized injury that if there is any injury, it belongs to the people as a whole, which this court has has always said does not constitute a special injury sufficient to confer standing.
So you do believe that a petition signer and a voter has standing not just to make sure the election comes off, but to make sure that the results of that election are implemented for some short period of time?
Perhaps
by
for
the
some
city.
short period of time, but if the court brings that out too far, then what you have is standing of every voter in Texas who may have ever voted in a petition, an initiative, or referendum election, and I don't think the court wishes to expand it that greatly or should.
Any further questions? Thank you, counsel.
Thank you.
Court is ready to hear argument from respondents.
May it please the court, Mr. Alan Parker will present argument for the respondents. Respondents have 20 minutes.
May it please the court, my name is Alan Parker. I'm the CEO and founder of the Texas Justice Foundation. I represent two clients in this case. I have the honor of representing Councilman Rob Todd and citizen activist Richard Hotze, who was one of the leaders in an event that the city has paid inadequate attention to throughout this case, which was an election by the citizens of Houston in which 200,000 people rejected sexual orientation as a protected status when they had the opportunity in a referendum election to focus on that.
Ms. Hadfield said that 14 months is too long, that Mr. Holtze should have brought this action some months ago. How do you respond to that?
Your Honor, I respond, once the people have spoken, then the final political authority has given the word in this country.
It's been 50 years.
I think it should be 50 years. We have statutes on the books that are 150 years old in Texas. Once the legislature passes a law, until it's changed, it stays in
That's
effect.
a positive enactment, not a rejection, so it's not a negative.
But the city council, the city charter provisions of Texas of Houston have very easy provisions for someone to bring that issue again to the people through the initiative and referendum process.
Why didn't they do it this time then?
Because the people have already spoken, Your Honor. The honorable thing to do is to give effect to the will of the people until someone changes that will.
Well,
We
is
don't
that-
simply say, it's 5 months after the election, maybe the people have changed their mind. Those who hold that view should go to the public, do a petition signature like Mr. Hotze
Well,
did.
but you're talking about the people in their capacity as a initiative legislature, is that right?
Yes, Your Honor.
I mean, that's how they get to do this.
That's correct.
But there's law over on the other side that each legislature's different and not bound by the one before it and could change their minds.
Well, that's a different law for a city government than a state legislature, Your Honor, because in 1913, the citizens of Houston added initiative and referendum provisions to the city charter.
But my point is they're acting in the same capacity as a legislature acts. Is that not true?
In conceptual theory, but as a practical matter, since they don't meet regularly like a legislature, in a
But
sense,
they have the opportunity.
they have the opportunity to do
meet
so.
and do these every 2 years if they wanted to, if they didn't like something. Isn't that right?
Your Honor, the day after the election, if other citizens didn't like the result, they could go through the initiative and petition process and put it on the ballot.
Then that gets back to why hasn't somebody done that this time instead of taking the route that they took?
Because there's no obligation. Your Honor, that issue was made by the city of De Leon, and city of De Leon, one of the cases where actually it was a Court of Appeals decision that rejected that argument, that citizens had to throw out the mayor in the next election, as Justice Heck suggested or something. Citizens don't have to go through the political process once there's been an election. They have the right to expect that the executive, whose job is to faithfully execute the will of the people, will follow the will of the people.
Taking that into account, then, what kind of injury has Mr. Hotze experienced that is particular to him and distinguishable from the rest of the public?
If I may put up my first exhibit on that point, Your Honor, this is Exhibit 1. This is a quote from Bloom decision, which was a unanimous decision by the Supreme Court of Texas just last year in June. And basically, the city of Houston made the same argument. You don't have any,
Well,
Mr. Bloom has no.
But this was in connection with an election to be held or the form of the election.
Yeah.
We're now at a different point in time in the process. So under these facts, what particularized injury does Mr. Hotze have that is distinguishable from the rest of the public?
Mr. Hotze was a signature signer, he was a circulator, he was a leader, and he was a voter in that issue.
And he did get his referendum to the public, and it was voted upon, and that has all been
Yes.
completed. And now he is a member of the public. That event is done. He's not complaining about that event because it has occurred.
But he is complaining that the entire results of the election have been nullified by the executive branch.
Why doesn't every citizen of Houston have the same complaint then?
Because some of the people voted the way the mayor is acting.
Well,
So
why-
there's a difference between winners and losers in an election.
Why doesn't he have the same injury then as all the winners so that, again, his injury is not distinct?
He probably does have the same injury as all the winners. This is like a voting rights case. I think we would argue that any
As to put it
voter...
up standing, you would have
Yes.
to prove up that you voted in the election and that you voted for the referendum to vote down the ordinance.
Yes, that's stipulated
So
by
only
the
people
city.
who voted for it would have.
Yes, according to ours. It could be limited on the facts, too. He was an initiative signer and a declarator. In my opinion, in
But
Bloom...
if I could, I just want to...
But I would argue for citizen, to answer that question.
All right,
Yes,
so
ma'am.
the answer is because he voted in the election
And
and
he was a
voted
winner.
for it, and he was
Yes.
a winner. That's what you say gives him standing.
Yes. Because in Bloom, you said they have the right, a justiciable interest in valid execution of the election. If you can have the election, but it can be ignored by the executive, what's the point of having the election? That was
Is
the
there
question
any
one of the
case-
justices asked Houston.
Is there any case where a voter in Texas, regardless of how they swear they voted, or how active they were in getting that vote, where they have been allowed by a court to bring an action for the enforcement of the popular will once the election process was completed?
I'm not aware of any other case where a mayor has put aside the results of an election, as happened in this case, Your Honor.
But this is
I don't know of any cases.
a brand new
It's
set of facts.
one step farther than Bloom. And it would be asked the question, if in Bloom you said, well, Bloom you went farther than just a right to an election. In Bloom you said you had a right to a fair election, because the question was the ballot language improper or misleading? And so it wasn't just a right to an election, it was a right to a fair election. This case is the right to the results of the election, that the executive will follow the will of the people. And if
Mr.
the
Parker.
day after the election, the mayor had said, I don't care what the results are, by executive order, I am going to make sexual orientation a protected status, then clearly, I think the city has conceded. Hotze would have standing. It's the same issue 13 years later.
You
It
talked
may go
about
to-
setting aside the election. Are there practical differences between an ordinance and an executive order?
Yes, under the charter of the city, there's no way to appeal by referendum an executive order of the mayor. And logically, there is a way to appeal from a legislative ordinance of the city, because the city has legislative authority. One reason that we have appeal...
Is the scope of the executive order as broad as it was under the ordinance? I guess is my question.
We believe that it is, yes, Your Honor, and the courts below agreed. And the city has not really appealed that issue on the merits. They've appealed only on the standing, but I'd be happy to address it. We won below, and we think it's clearly the same issue. It's clearly the results of the election are being overturned. And, you know, this court isn't going to have a rule that says, well, standing says your interest in an election is pretty good for 3 months after an election, maybe 6 months. No. If you have an interest in preserving the validity of election because you worked in it, you voted in it, you were the winner. We don't want losers coming to court trying to set aside the results of the
Well,
elections.
you admit, I mean, none of these past cases have set up a test that you had to sign the petition or be the person who
Well-
thought of it. And as far as voting, that's been a secret ballot in Texas for a while.
Well, that's true, but when you're as active as someone like Mr. Hotze is, there's no secret where you stand
but-
on the issue.
But you would be for us erecting some type of test of
Sure.
activity. And what would that,
In this case,
Possibly.
voting, Your Honor. This is like Baker versus Carr.
but once you vote, I mean, if you voted, You can say you voted however you voted, and as long as in your precinct people voted each way, that really can't be contested.
Well, I don't think anyone would bring a suit to enforce the results of an election unless they had voted that way
So
in the
that,
election.
so voting one way or the other is really not a useful
Well, I
way
think-
of winnowing
Your Honor,
down the possible
The
class. of-
secrecy of the voting booth is for the protection of the voter. If they want to stand up and say, I'm proud to say I voted against this ordinance, and the mayor is ignoring it, the results of the election, and I, as a citizen, want to go enforce this referendum we had.
And since the secrecy of the ballot is in our rules of evidence, you think we can make declaring how you voted a requisite for standing?
Well, I think that's the burden on the plaintiff to allege their standing, Your Honor, as we have in this case, and in every case.
But we are largely making all this up, one way or the other. There's no case,
Well,
there's no case in point either way in Texas law.
That's true.
here.
In that exact sense, yes, Your Honor, it's a case of one further step from Bloom. In Bloom, no one had voted in the election yet because the election hadn't been held. But you clearly said people have the right to have an election. Why is that? Because that's how we decide these issues in a democracy. What is the role of the executive? To faithfully execute the will of the people.
But are you saying that the city of Houston is now forever precluded from doing anything in its local government with respect to this issue? The city council cannot pass an ordinance, the mayor cannot pass an executive order because a referendum defeated something, not did something positive, as Justice Owen was saying. Are you saying that now, forever, the city's precluded from ever addressing this issue?
The city is not precluded from it, Your Honor, but the mayor is not the person that has that
Can the
authority.
city council pass an ordinance contrary to the results of that referendum election?
Your Honor, our position would be that they could not, that it would be up to the citizens to initiate a petition to change that.
What
So
about
having-
after all the voters are deceased?
Well, it's kind of a perpetual right, Your Honor. If you live here, you get to vote, and you're over 18.
So once you've had a successful referendum on an issue, that's it, that's the way Houston's going to live from now till forever, and
It would
there's
take
not, I mean,
another referendum.
Until the citizens of Houston decide to change that, which is their right, their privilege,
That's not
and
what
the
the charter
proper
says,
way.
though, is it? I mean, shouldn't the charter govern that issue?
It does, Your Honor, and it says that the people shall
But does
do
it
that
say-
by initiative.
It does
and
not say
petition.
that it's a perpetual.
No, no, absolutely not. It just prescribes the manner in which it's changed again, which is by initiative of the people. The court talked a little about who the final authority
What
is.
provision of the charter are you looking to that a referendum that defeats something as opposed to has enacted something? I mean, you're dealing with the negative here. I mean, what provision
Yes.
of the charter are you looking to for this authority that it would take another popular vote in order to reverse that referendum?
It says basically, Your Honor, that if the city passes an ordinance or something like that, that by initiative and referendum, that it cannot be changed again
But
without...
you didn't pass an ordinance, you defeated something here. That's my point is I thought the charter read that if an ordinance had been passed, it could be repealed by referendum. You don't have an ordinance here that you're trying, that is being repealed. You have the exact opposite. You have a negative.
That's true, Your Honor,
So
but
what
it-
provision of the charter are you saying prohibits the government from being able to act in the manner in which either the mayor has or if the city council chose to pass an ordinance?
It's Section 9, which is what you're referring to, and the rule of liberal construction of initiative and referendum.
But
Because this court, ever since 1937, has said we must liberally construe initiative and referendum provisions. It is a limited government provision.
But doesn't it require a popular vote to be held to repeal or amend a resolution or an ordinance that is enacted, a positive enactment, so that provision's not applicable?
It's not directly applicable, but I think with the
And there's
rule
no
of
other,
liberal,
and there's no other
provision.
provision you're looking to?
No.
And if that's the case then, if as opposed to an executive order by the mayor, the city council had enacted an ordinance similar to the executive order, would Mr. Hotze have standing to come in and complain about that ordinance at this point in time? Would we have the same controversy before us?
If Mr. Totsi simply lost a vote in the city council, I don't think he would have standing at this point, Your Honor.
Well, then
Because-
why, if that's the case, is this not a political controversy at this point in time that would require some action by the city council as opposed to coming to the courthouse?
Well, Your Honor, the mayor has absolutely no power under the charter, and under the city council, and the record will reflect, Mr. Todd cannot get this on the city council's agenda without the mayor's concurrence. That's on pages 43.
Has there been any effort to do that?
Your
Does
Honor,
the record reflect that?
the record reflects that the city, on page 46, 47, and page 66, says that the city councilman does not have authority to put it on the agenda unless the mayor wants to.
I'm really trying to take you back to one
Sure.
of Ms. Hatfield's points, and her point is that you're here too soon. That in fact, there really is a forum for this, and in fact, the way the local government operates, until such time as the city council acts or fails to act in some way, that we have a political controversy, and you are here prematurely asking the courts to intervene. Would you respond to that argument?
Yes, that ignores the election, and City Councilman Todd feels that his duty as a city councilman is to give effect to the election of the people that occurred in 1985. He does not feel that he has any power, authority, or responsibility to ask for another vote of the city council when the people have spoken.
I understand that he may feel that way, but would you respond to her argument when she says that the controversy is not right for that reason?
Yes, Your Honor, I think that you would then be completely gutting your responsibility as a court, which you have expressed, for example, in Glass. As a corollary to the rule of non-judicial interference with elections, the courts are duty-bound to prevent all interference with the political power of the people. You're forcing the people, after they've had an election and expressed their will, to go back and do it again just because the executive branch is ignoring their will.
But why
And
should
once
we-
the people have spoken, then a citizen or a city councilman, and in the record, this city councilman has no power to place it on the agenda, Your Honor. You're asking him to do
Justice
that?
Hankinson asked you that question, and we didn't,
Okay,
I
excuse
don't
me.
think we got an answer. Has he tried to put it on the agenda?
He has not tried to put it on the record in terms of having an actual vote.
So we don't know if the mayor would let him put it on the agenda or not.
No, we do not. We know that the mayor in this case on the record has said that that is totally discretionary with the mayor. We know that the mayor has ignored the votes of 200,000 people in the city, and we know that, but we do not, we don't speculate. We do know the mayor has already passed the executive order, and that the mayor did not seek
But
executive
there's been no
authority.
attempt to override that at the council.
None whatsoever, Your Honor.
Texas has always been particularly strict about requiring an actual case in controversy. We've read it into our Constitution. We interpret declaratory judgments more strictly than most, if not all, other jurisdictions. Why shouldn't we wait till somebody in the public has actually been harmed by or is claimed to harm from the executive order, rather than letting politicians fight it out in a theoretical battle and ask the court to make a judgment call?
Well, Mr. Hotze fits
why
that
wouldn't- why- but
category.
why
He's a
wouldn't this-
member of the general public who's been
Well,
harmed
I'm
by the
asking
statute.
about, I thought
If
we
you
were
wanna go
on
back to
Todd's
Todd,
half of
yes.
the case. Why, particularly if you believe in the limited powers of a judiciary, should we be interfering essentially at this stage before somebody comes in and says, I've been harmed by this government act, me personally?
Well, keep in mind, the city is arguing that not only Mr. Todd, but no member of the public can sue the mayor also. And we do, well, I'm not conceding Mr. Todd's standing by any means, I'll address that.
But Mr.
Citizens' standing
Hotze
more
is not,
important.
Mr. Hotze has not alleged that he's tried to get some employment that's been, or that somebody else got a job that he would have gotten had the executive order not been in place.
He has the same injury to his right to vote and to see that his vote is carried out that was present by Mr. Bloom.
But
or
we've
Glass.
never allowed voter standing in Texas, just as a,
Your
you're a
Honor-
voter and therefore you can complain about constitutionality. or
Well, the only
otherwise.
reason for that in the prior cases, there had been no election yet, Your Honor. Those people were suing to see that the election was held.
But are you saying that as a voter, that gives me the right to complain of any city ordinance that I'm affected by or any act of legislation? And don't we have to overrule a lot of cases if we do that?
No, Your Honor, there hasn't been any denial of voter standing in that. Any person injured by an unconstitutional ordinance can sue to do it. But well, excuse me.
Having been a voter,
In
it's just bothering to
yes.
register a vote, does that make me injured?
Well, this is limited to initiative and referendum cases, Your Honor, because
Well, I know
you
it is,
have-
but that's not,
That's
And
Mr.
Mr.
Hurtsey.
Todd is
Yes.
is in this situation. He's not a person who didn't get, I mean, he expressly, his job is not affected by this. It's only job in city government, I guess, that's not. And why, if your general approach is that the judiciary should not be poking its nose, as it were, into every governmental decision, why should we decide this case before there's someone out there who claims an economic injury, that what's happening in their life is different because of this government action?
Your Honor, an independent judiciary is essential to the separation of powers doctrine. In the city of Pittsburgh case, for example, when they let the city councilman sue the mayor, they specifically said, if we want to have the legislative branch acting as a check on the executive branch, then we as the judiciary must be able to come in and referee the dispute. Because if you simply say the mayor can do whatever he wants, legislative council standing we're not going to allow, then there is no referee. There is no limited government enforcer, which is what the judiciary should be.
Do you think we should look to federal cases and other state cases that deal with the legislature and the governor? Or should we treat municipalities, where both branches are a creation of the legislature, differently?
Exactly, Your Honor. I would say that the municipalities are not entitled to deference. We're talking about people like the mayor of Dime Box and the city councils, and some of them don't have much experience. I think this is not as high a level of branch, and by its very nature, we have initiative and referendum limiting municipal government, which we don't have on our state legislature, and certainly we don't have at the federal level. I would say this is a unique state issue, though I think it's also consistent with the federal cases like Coleman that did grant legislative standing to a state legislator.
With the buzzer
I'm sorry, I was
I
answering
don't want to get into how much viability Coleman has.
But let me ask you if you would, if Mr. Todd, if the council had taken up this issue and voted down an ordinance, and the mayor had issued the order, there had not been a referendum, would Mr. Todd have standing to challenge the mayor's action?
No, I don't think he would.
Why not? What,
As a-
you think the initiative is what makes all of it?
That and being, that, yes, I think the initiative is what makes all the difference in this case. I think if there had been no...
That doesn't help Dime Box. They don't have initiative in referendum.
Well, I'm not sure. There is a municipal code
I'm
provision.
assuming, I don't know.
It's in the municipal code, so I assume it's fairly statewide, Your Honor, that we have initiative and referendum at the local level. And so, you're right. If the mayor had done the proper thing as mayor to perhaps bring this to the council, and he was simply a losing member, I think that's what Raines indicates. If you're losing your vote because other members of your own branch of government don't agree with you, don't come to the judiciary. But in this case, he is ignoring the will of the people who spoke in this election. If Todd, if Todd has no standing, and the citizen, Hotze, has no standing, who was active, then there is no check and balance on the power of the executive branch.
You don't really care if it's either Todd or Hotze or both that have standing?
In terms of protection of the public, Your Honor, it would be, I think any citizen ought to have the standing that's been on the winning side of the election to preserve an initiative and referendum election. It could certainly be limited to the initiators of it also, and that would give broad protection to the public.
Let me ask you, I wasn't clear on your answer to the activism aspect of Mr. Hotze. Do I understand your argument is that his injury is different than any other of the 200,000 people that voted for that initiative in 1985 is because he's an activist? And so everybody knows where he stood.
Factually, that's true.
And if so that's the only thing that makes him different than any of the other ones in this case.
He was a signer of the petition.
No, is that correct?
That is factual.
Is that the standard that you want us to apply here?
No, Your Honor, I'm saying that's factually true, but I don't think legally that's the difference that should make an impact.
Well, what else is there then for a criteria to say that Mr. Hotze is entitled to sue, to rescind
it would
that
be
order?
Any citizen who is on the winning side of the election should have the right to prevent their vote from being diluted, just like any citizen in a gerrymandered district can sue, even though their vote is just as diluted as everybody else's vote, even though they suffer no injury different from the general public.
But that's not our jurisprudence.
Well, you've indicated in tab that you wanted to follow federal jurisprudence, Baker versus Carr, and in that case, it was even more difficult to fashion a judicial remedy. But here we're just asking the courts to construe a document, the kind you construe all the time. It's a city charter.
Well, but you've already answered Justice Hankinson that what you're arguing doesn't fit under the only thing that you're arguing.
No, we have standing to enforce the election. Whether somebody else wants to change it or not, that's a different issue. That's a hypothetical question. In this case, we're suing to enforce the election that actually occurred on January 1985. That's why we have standing. That's, on the merits, Your Honor, maybe the city, the Court of Appeals felt that the mayor did not have this power. Maybe on appeal, that might be a different argument, where he actually has the power. But clearly, we're the ones injured if he did not have the power to set aside the results of that election, which we don't think he did. This is a country, and Your Honor, to go to judicial activism, this is a country which is a rule of limited government, not executive fiat. And if the judiciary is not willing to enforce all of the limitations on the power of government, government will constantly expand. Those in authority always think that they know what's best. They wouldn't be there if they didn't do that.
Any other questions?
Thank you.
Thank you, counsel. Can you address the argument raised in the respondent's briefs that this court does not have jurisdiction over the Todd question?
Oh, yes.
Because that was merely an interlocutory order, which there was a statutory right for an appeal to the Court of Appeals, but there's only a conflict on the Hotze half of the case, so there's no conflict jurisdiction here, no other grounds for jurisdiction, and we shouldn't be paying any attention to it.
Yes. I cited in my reply brief a decision of this court decided in the year 2000 in which this court took an interlocutory, or took a look at whether the courts below had jurisdiction. And I think that inherent within this court's power, in every court's power, is to look to see whether they have jurisdiction over the subject matter.
I think what the Chief is asking you, there's no dispute, at least among the justices on the Court of Appeals, that they had jurisdiction over Todd. The only dispute is, did they have jurisdiction over Hotze? And I think what the Chief is asking you to get right to is, since no one is complaining about Todd, how do we have jurisdiction over that aspect of the appeal? Why is it that we aren't just limited to the subject matter of the dissent, which is Mr. Hotze's standing?
Because the court to adjudicate, to render any opinion that does not have a person with standing below is an advisory opinion prohibited by the open court.
We could render opinion with respect to Mr. Hotze, clearly. How do we have jurisdiction to render an opinion with regard to Mr. Todd when there's no dispute, at least among the justices on the Court of Appeals, that they have jurisdiction over Mr. Todd?
Well, whether the Court of Appeals agreed or not, that there is jurisdiction over the Court of, jurisdiction over Todd, the city has asserted from the beginning, and it cannot waive its right to challenge standing of Mr. Todd.
Well, this is a simpler, this is purely our jurisdiction. And this was an interlocutory order on, as to Todd. There's still supposed to be a trial someday as to that. And prior to 1995, it would have been very hard to get that case reviewed, but now it can be reviewed by the Court of Appeals, but only by the Court of Appeals on an interlocutory appeal. And it can't come to us because there's no final judgment unless there's some other basis for jurisdiction, which has to be a conflict in courts of appeals, which nobody's alleging, or a dissent. And that's the basis for the jurisdiction you've alleged, is that there's this dissent in the Court of Appeals by Justice Amidai. But that dissent only went to the Hotze half of the case.
That's correct.
Now, if Hotze hadn't complained, if he had just gone away, it probably we wouldn't have any right to hear the Todd case. The hook is there is this dissent, but I'm asking you, is that enough? is the fact that there's a dissent on the other half of the case by a party who wasn't a necessary party. This could have been two separate lawsuits. Is that enough to get us jurisdiction? And this is probably an open question, but
It is an open question that
I'm interested in your best argument.
It sounds like the court's going to adjudicate that question. I would take the position that this court always has jurisdiction to determine whether it or the courts below had appropriate subject matter jurisdiction. And to me,
Then a lot of the legislative limitations are worthless. That's the case.
well, I would disagree. I think you do have that power inherently.
Why doesn't initiative make this different? Why doesn't the initiative referendum part of this make the standing issue easier? Because the argument of respondent is the courts should give effect to the political will of the people.
Well, I'm not sure that I've quite followed your question, but in this
The people
case,
don't want the order, the mayor does, and the court should give effect to the will of the people.
the key here is the referendum that defeated a proposed ordinance. Hotze has a political remedy just as does Todd. Hotze can now petition by initiative an ordinance that would have the effect of contravening, just as Todd can do so in his legislative body.
If he did that and the council repealed it, could he sue?
If he did,
If he passed an
if
ordinance
he passed an ordinance,
and the council repealed it, could he sue?
I think you might have a right controversy there.
Any voter? Any citizen?
No, not any voter. Someone who voted in that initiative election.
So you think it makes a difference whether they vote for or vote against?
No, I'm with Chief Justice Phillips on this. My vote is secret, and my right to that
Well,
ballot
but
is secret.
my point is, you think that if they're voting for an ordinance that passes,
Oh,
the
I'm sorry.
referendum passes,
If the referendum,
then they might have standing if the council tries to set it aside. If the referendum is to prevent an ordinance and the council conflicts with that or the mayor, you think they don't have standing.
yes, the distinction is in the purpose, the difference in purpose between a referendum and an initiative. An initiative enacts law. A referendum, in this case, defeated a law, and I do believe that is at the core of the lack of standing.
Once a law's
lack
been
of special interest.
passed, why wouldn't they always want to do it? I don't know that I have these straight. Why wouldn't you always want an initiative and make it a positive statement of law?
Because it's harder, you need more petition signatures.
Okay.
So, this was a referendum that set aside a city ordinance.
That's correct.
And so the city council refuses to set aside the ordinance. Then who has standing to make a complaint that the ordinance should be set aside?
You're talking about an initiative that creates an ordinance?
No, I'm talking about a referendum that defeats, you said a referendum defeats a city ordinance.
It could, yes.
So
And
the
in this case did, in 1985.
And so who can sue to force the council to then set aside the ordinance?
Any voter in that initiative
Referendum.
election, that referendum, if it enacts a law. If it defeats a law, I do not believe there is standing.
So in this case, referendums that defeat ordinances, there is no standing to force the council to set aside the ordinance.
That would be my position.
And if you're wrong on that position, then you're wrong in this case.
No, because that's an entirely different hypothet in that case. Because in this case,
Is
council
14
has,
years, I mean, what fact in this case makes that a different case?
in relation to the Hotze standing.
There's a
issue,
statute of
it's the-
limitations on the referendum.
It's the remoteness in time, yes. The
Remoteness.
further away you move from the referendum election, the more generalized the grievance becomes. The more the grievance, injury, if any, occurs to the voters as a whole, and not to any particular voter.
So the 21st Amendment, I guess, which repealed prohibition, has been so old now that that the federal government's free to regulate the importation and sale of alcoholic beverages just because it's been a long time since they ratified that 21st Amendment.
I think that position is if there...
Somebody could claim a complaint
If
about
there
that.
is a specific current act of a legislative body that attempts to override that, then you might have a right controversy. And unless you do that, it is my position that there is no right controversy.
Any other questions? Thank you, counsel.
Thank you. This has been my first opportunity to argue before this court, and I am reminded at this point that any experience that does not kill you makes you stronger. Thank you.
That concludes the argument in the first cause, and we're now going to take a brief recess, and the entire court, with Justice Abbott, will return.
All rise.
Thank you. Please be seated. Court is ready to hear argument from petitioners in Lawrence versus CDB Services and Lambert versus Affiliated Foods.
May it please the court, Mr. Brian Heinrich and Mr. Coleman Young will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Heinrich will open with the first 15 minutes. Mr. Young will present the rebuttal.
May it please the court, counsel. First of all, on behalf of our clients, the Lamberts and the Lawrences, I want to thank the court for agreeing to hear this very important case. We're here about today the legality, or rather the enforceability of a waiver signed by employees of non-subscribers of their right to sue those employers at common law. And in order to address this question, it's first necessary to look at the Workers' Compensation Act that's in question here.
Mr. Heinrich,
Yes, Your Honor.
does the statute expressly prohibit this kind of contract?
We assert, Your Honor, that it does because of the way it was set up. The way it was set up...
But do the words of the statute reflect that?
Expressly not, Your Honor. But the statute was set up to draw a clear line between subscribers and non-subscribers, and clearly expressly contemplated a common law cause of action against non-subscribers. The way we know that is because the Act specifically set up, specifically delineated how an action against a non-subscriber would go, by specifically setting forth what common law defenses would be available and which ones would not.
Were these waiver agreements in use the last time the Compensation Act was overhauled?
Your Honor, I do not know any specific, these specific waivers in these two cases, I do not believe those waivers were being used.
No, I mean generally speaking, were employers using waivers like this when the compact was overhauled?
I'm not specifically aware of any, Your Honor, but I would assume that they were being used at that time. That would be my assumption, but I don't know for sure.
In the Hook case that's cited, the waiver went back to '89. But do you know if that was, if they were innovation in '89 or if they've been in use for some time?
I would assume, Your Honor, that they had been used for some time, but I don't know that for sure.
Why didn't the legislature address them?
I would assume that the legislature did not address it because it did not need to be addressed. The Act itself clearly says if you're a subscriber, the quid pro quo is I can't be sued for common law negligence, and in return, my employees get a some certain amount of benefits without having to prove negligence on anybody's part. If I'm not a subscriber, then I must face common law responsibility as set forth in the Act, as specifically described in the Act with regard to what common law defenses I may assert, which common law defenses I am not allowed to assert.
If the non-subscriber's plan is better, you wouldn't agree. I mean, you would, your position would be totally different.
It would be, Your Honor.
And why? There's evidence in this record that the employer's plan is better, that it offers benefits that are not offered under the workers' comp statute.
There's evidence in this record that some parts of the plan in question may be better than some parts of the workers' compensation plan.
And why can't we look at it as a whole and determine if it's better? Why can't an employee choose to, they don't have to opt into this plan. Why can't they choose that they like these benefits better, the benefits that are offered under the employer's plan, and just go that route? Why shouldn't we allow that to happen?
As long as the plan offered by the non-subscriber is equal to or better than the Workers' Compensation Act benefits, then it's perfectly appropriate for the employee to enter into that agreement.
But how do we make that qualitative analysis? How do we determine whether it's equal to or better than? It may not have the same benefits, but the argument's being made that the employer's plan is better because it offers things that are not offered under workers' comp. And why can't an employee decide those things are more attractive to me, and that's why I'm going to opt in?
Your Honor, in theory, I think you can look at a plan and compare it to workers' comp. Practically, though, I do not think it's possible to do that because there are additional benefits offered to employees of subscribers under the Workers' Compensation Act that are impossible to get as an employee of a non-subscriber.
Such as what?
Such as protection from insolvency. Under Texas law, the insolvency pool guarantees unlimited protection due to insolvency of a workers' compensation insurance carrier. There is not unlimited protection for the insolvency of a private insurance company under a private plan. Furthermore, there's certainly no protection for insolvency if an employer is funding this on its own and happens to go belly up after this employee agrees to accept that particular plan.
Let's start at the beginning. The employer could choose to be a non-subscriber.
The employer?
The employer could choose to be a non-subscriber, in which event certain activity occurs. Let's suppose the employer chooses to be a non-subscriber, but then with the employee says, but we have a different deal. We will provide some benefits irrespective of you have to prove negligence in the workplace because we're non-subscriber. So you have to prove negligence in the workplace. But we have a deal where if you agree to waive that negligence, which we could put you in the posture of by being a non-subscriber, but we'll offer some benefits out there. We'll actually give you some compensation in exchange for your waiving a claim against us for our negligence. And we have common law provisions out there that talk about clear and conspicuous, and everybody knows what's going on here. And you get compensation, you get consideration for giving up that negligence. Isn't that contemplated by the compensation statute? I could choose to be a non-subscriber, in which event you've got to prove negligence against me to get a recovery. Once they're outside the comp scheme, then, can't the parties then enter into some sort of contractual arrangement where I give up a claim against you for your negligence in exchange for consideration for me giving that up, and that could still take, it could be in the form of benefits?
Well, that's what has happened in these two instances, Your Honor.
But you're arguing the parties can't do that under the scheme because it's a pervasive scheme. They can't do that.
Two reasons specifically. One, that contract that they enter into, number one, we assert violates public policy of set forth by the Comp Act, and more specifically, violates the statute itself.
That's where I'm not sure I understood one of your responses to Justice O'Neill's question. You said it would be okay, as you put it under the statute, if the benefits were better. And I don't understand either the statute prohibits these kinds of agreements or it doesn't. Where in the statute would it exempt a plan that offers higher benefits?
It would not. Well, the statute is set up, Your Honor, so that as an incentive for employers to provide comp for employees, and that's the way it was set up back in 1913 when it was first enacted. As an incentive, a penalty provision was put in the Act that said if you're not a subscriber, then you're going to be subject to a common law cause of action.
Then why shouldn't we say then that you can't contract to do this type of thing, that you either have to be a subscriber or you're not?
The Act says you should either be a non-subscriber.
But you said that it's okay to contract if the benefits are better.
The quid pro quo, the key to the Workers' Compensation Act as enacted in 1913 was it's okay for an employee to give up his common law right to sue as long as he receives the legislatively determined benefit package that he can get by being an employee of a subscriber.
But the reverse isn't true. He can contract, but there's nothing, as the question from over there, that says when he does contract with the employer that the benefits have to be better than workers' compensation. Isn't that true?
If an employee of a non-subscriber enters into a contract in return for benefits that are equal to or greater than the Workers' Compensation
The Workers' Compensation Act doesn't require that non-subscriber contract to say, and these benefits are better than workers' comp, otherwise this agreement is void. It doesn't say that.
Does not expressly say that.
And so where does that theory come from other than a Court of Appeals decision?
Again, the Act was originally enacted to either...
But aren't we working at least from 1989 forward instead of 1913, since
True.
we're under a new whole scheme, as we talked about in Garcia?
Yes, Your Honor, but the critical points of the original Act and in the Act as it exists today are the same with regard to the questions before this Court today, and that is it against public policy? Is it contrary to statute as it currently exists for an employee of a non-subscriber to be able to waive his right at common law?
Mr. Hogan, if you would go back to, you listed 2 points. The contract violates public policy and it violates the statute itself. But in response to Justice Gonzalez's question, you said there's no express provision of the statute at issue. Would you please tell us how this kind of a contractual arrangement violates the statute itself, specifically?
Specifically, the statute says if you're a subscriber, then your employee can't sue you. If you're a non-subscriber, you're subject to a common law cause of action, and here's how we're going to do that. Here's how this Act is going to work. The statute itself specifically expressly contemplates a common law cause of action that exists against a non-subscriber.
And what you're saying then is that it violates the statute because by doing this kind of an arrangement, the employee can no longer sue the employer on a common law cause of action with the various restrictions that the statute imposes? Is that the specific violation you're complaining about?
Yes.
All right, and then in what way would you be specific and tell us how this type of contract violates public policy?
The public policy behind the Workers' Compensation Act is to encourage employers to provide coverage for workers in the state of Texas. And in return, or as an incentive to get as many employers in Texas as possible to provide that coverage, they placed a penalty in the statute to discourage employers from doing that. And if these waivers are allowed to stand, you have, in effect, eliminated the penalty that the legislature placed in the Act to encourage employers to provide workers' compensation.
Is it your position that San Antonio was correct in its interpretation that these types of contracts and waivers should be allowed under certain circumstances, that is, when the benefits are at least what someone would get under the comp statute, or is it your position that they are absolutely prohibited?
If the benefits provided under these plans are as good as the benefits under the Act, then they're okay.
Why is that? Sorry.
You don't think that can ever be? You don't think that can ever be? You said
I do not think that can ever be.
Well, I mean, that's ridiculous to say. It would be okay if something that can never happen would happen.
I think in theory, as I said, in theory you could compare, but I think in practical terms it's impossible to do that comparison.
If you could compare and could practically compare, who would make that decision? Is that a law question?
I think it would probably be a factual question.
It's a fact question.
But should we adopt, this is an issue, I'm not smart enough to really can tell the difference between whether this benefit is comparable to another benefit. This is an issue that's going to be litigated in every case. So should we adopt a rule that requires us to look to compare the benefits to see whether or not the contract is better or not?
No, I think the rule that should be adopted is that these waivers are void.
Well, let's suppose we agree with you. One of the employers in this case has already paid over $200,000. What happens to those benefits paid and you go to a common law trial? Is there some sort of credit, and how does that work?
If the jury awards, if for instance, Mr. Lawrence has received $225,000 in benefits, and a jury awards him $224,000 in damages, then CDB owes him nothing.
Is the jury told that he has a contract and that he's been paid under that contract?
I would think the jury would not be told of that, because again, it's a negligence action, and the evidence of benefits. Well, if the benefits are paid by the employer itself, then the collateral source rule would not exclude the jury knowing about that. If it was paid by another insurance company, then possibly the collateral source rule would prevent the jury
Once he
from knowing about
brings
that.
this suit, can he still keep collecting benefits under the contract, or, and you'd say that still doesn't constitute an election?
If the agreement made the basis of this waiver is void, then no action on his part can validate that.
Even continuing to accept the benefits? But don't, you have to do something with the benefits. If I understand what the CA said, that he still, Mr. Lawrence continues to receive benefits, and that Mr. Lambert received $58,000 before he sued, but then he declined to accept any more. Is that factually correct?
That is correct.
But that neither of your clients have ever tendered or paid back any benefits after they filed the suit. Is that a necessary part of this process, that you can't accept the benefits and then sue for something else and keep them?
No, the waiver itself is what makes the situation, the waiver is what is void. The plan itself is not void. And a non-subscriber could offer its own plan without the waiver, and the employee could receive these benefits and still retain its right to sue.
So the waiver, the bad part you don't like is not being able to sue to get more.
That's the part that we believe, Your Honor,
Let me ask you
violates
a
public policy.
procedural question that I'm not clear on. You have two clients, and the Court of Appeals said that Mr. Lawrence did not raise it as an issue in his summary judgment response. One, that the election waiver he signed violates public policy and is void because the benefits are not equal. And secondly, that Mr. Lawrence didn't raise the estoppel defense. But Mr. Lambert raised the issue of don't equal each other, therefore it's void. Where does that leave Mr. Lawrence if he didn't raise it, and how can he benefit by any opinion that would be favorable to your viewpoint if he didn't raise it?
Well, Your Honor, we believe Mr. Lawrence did raise it at the appellate level and at the trial court level to begin with, because it's clear in the response to the motion for summary judgment that Lawrence's argument was that this waiver is void as against public policy, and cites two cases, or cites one case which cites the Hazelwood case, which is the first case that really talks about a comparison of benefits. So we believe it was raised. But secondly...
So are you saying then the Court of Appeals, when it looks at the record and it just says this is void, they've got to then speculate that because he cited one case that cites another one that says something, that you read all the way down through that and finally conclude, aha, here's my argument, and I'm going to apply that doctrine?
Well,
aren't there some cases that you don't have to search as a Court of Appeals those kind of records to find out those things that you're supposed to raise the ground, otherwise you waive? Both were summary judgments, weren't they?
They were.
So if you didn't raise it, you lose it, isn't that right?
If you're required to specifically raise any positions contrary to summary judgment, but the Supreme Court, in two different opinions, are clear that there's no such thing as a default summary judgment. And if a movement is making a claim for summary judgment, as CDB was in this case, based upon a waiver, they're required to establish that there were no questions of material fact that would prevent them
Well, but
from...
this is not a factual problem. This is a legal question we're trying to answer. And I don't get that there's any dispute on the facts, except what you're now saying, that he did raise it, and the Court of Appeals said, no, he didn't. But that's a matter of looking at the record. We're just looking at known facts, and we're going to try to apply this statute in the way that you suggest.
And under the law, Your Honor, even if a non-movement does not file a response of any kind to a motion for summary judgment, that does not preclude that non-movement from attacking grounds for summary judgment as a matter of law and appeal. And since public policy...
Yeah, but don't you have to say why specifically so that the trial court has the opportunity to understand the argument even when you're responding to a summary judgment, which your clients did here?
For instance, Your Honor, taking estoppel is one of the things you raised. If Lawrence had not, which Lawrence did not, specifically attack estoppel in the response to the motion for summary judgment under the law of this state, if, as a matter of law, estoppel cannot apply, that Lawrence is not prohibited from raising that ground, that legal point, on appeal of that summary judgment.
And what's your case that says you can do that?
The McConnell case, Your Honor, and also the City of Houston versus Clear Creek.
Mr. Heinrich, having accepted the benefits of the plan, why aren't your clients stopped from now challenging the validity?
Because the validity of the waiver itself is the essential question. If that waiver is void, then no action on my client's part can validate that, and therefore he is not stopped by accepting benefits under that particular plan.
So to follow up on that, let me just be sure. If there is a business that is owned by the employees, and they all get together and they say, we don't want the expense of workers' compensation insurance. We're just going to agree among ourselves, we're going to take this risk. We don't think it's very high that we're going to get hurt on the job, and we've got a health plan that'll cover what it covers, and therefore we all agree that we don't want this, we'd rather have the profits. Your view is they can't do that?
My view, Your Honor, is that agreement would, if they waive their common law cause of action, then that violates the policy of the Workers' Compensation Act.
Well, they could do it if the benefits were better.
If the benefits were better.
All right, now, under affiliated's plan, there are lifetime medical benefits?
Well, there's somewhat of a dispute in the Lambert case about whether there are lifetime medical benefits.
Well, I believe that's been conceded on appeal, hasn't it?
On appeal, they've conceded. I
Okay.
believe that they're...
If there are lifetime medical benefits, and there's a significant benefit that this employer plan offers, isn't there? It's non-occupational injuries are covered as well. And that is a significant benefit over and above the Texas Workers' Comp statute. Why can't an employee decide that is a very important benefit to me? If I'm injured while I'm mowing my lawn or driving around on the weekend, I'm covered for lifetime medical benefits. Why can't we let an employee make that choice? That is a superior benefit to him than under the Act.
The employee can make that choice to accept that, but he shouldn't, in order to get those benefits as an employee of a non-subscriber, he shouldn't also have to give up his right to sue at common law.
Let's suppose that, as I think you've sometimes said, that a superior plan might not violate public policy and might not call for this waiver. And you say that's a fact question, but is the finder of fact to be charged that they're supposed to look at the plan overall as it applies to all potential employees, or as it applies to this particular injured employee? Because lifetime medical may be great. Clearly for the yard mowing injured person, that plan's better. For somebody injured on the job with serious disabling injuries, the comp plan might be better.
First, let me say, again, in theory, I think you can compare. Practicality, I don't think you can come up with a plan that equates the workers' compensation system, number one. But in direct answer to your question, when you look at public policy, you can't look, the law says you're not to look at the specific impact of a given case. You should look at the overall impact to society in general. And it may very well be that the two plans offered in this case, the Lawrence plan and the Lambert plan, are much better than a lot of plans out there. But if these waivers are allowed to stand, then nothing would prevent an employer such as Affiliated or CDB from putting a plan together that offers an injured worker $100 a week and says, hey, look, this is great. We'll pay you $100 a week if you'll just sign this waiver.
Well, let me ask you a question about that public policy. If we conclude that the statute does not expressly prohibit these kind of contracts, then your argument is reduced to one of public policy, correct?
That's right.
And as you acknowledge, the legislature has been very active, necessarily so, in establishing what the public policy is with regard to workers' compensation matters. And this is the kind of matter that commands and demands extreme amount of public input, is it not?
It affects potentially every worker in the state of Texas.
Then why would it not be preferable to give this to the legislature to decide what the public policy should be, as opposed to this court deciding what public policy should be?
Well, again, assuming without admitting that the statute does not expressly prohibit this, and we are looking at a public policy argument, the law gives this court the power and ability to decide this on public policy grounds.
But why would it not be better on grounds somewhat similar to what we said in the Ozarka case for us to defer to the legislature's expertise in deciding public policy matters such as this?
This court has the power to do that and can do that more than likely on a quicker basis than the legislature would be able to do that. And what we're talking about here are issues that are affecting workers every day. And I would assert that this court has the power to declare that this violates public policy and has the ability to do that.
If we declared it violated public policy, would let me start over. Let's assume the negligence has occurred. The worker has a cause of action. The employer comes in and said, listen, now, rather than suing us over this, why don't you just agree to release us of all liability for this negligence that occurred out here, and we agree to provide you with lifetime benefits? Would that be okay?
That would be just fine, Your Honor.
Now, that's okay because the parties already know their status. There's already been an injury, already been negligence, and so they can all agree to settle that. And your problem is that in this circumstance, since the parties really don't know their status, they should not be able to contract in advance for how they'll handle it when there's negligence.
Contracts in advance to exculpate another party from negligence are okay unless they violate public policy, which...
Okay. And haven't we already broached the public policy issue there by saying if it's an exculpation clause, then the clause has to meet certain criteria. Otherwise, they're void against public policy, and that being that they have to be conspicuous and they have to be set out so that the parties are aware of that. And this satisfies that consideration. Then this agreement, conspicuous, set out, doesn't it satisfy what we've previously said about exculpation clauses?
It's our position that the waivers in issue do not meet the law with regard to fair notice and the express negligence test and conspicuousness test as they exist in the law today.
Any other?
Yeah, well, I'm not quite clear. Where do we get the public policy that you say is violated that we can hold it a void waiver? Do we decide an ethereal public policy? I mean, which policy, whose policy is it that this is against that you think?
It's the public policy set forth by the legislature and how they
that gets back to Justice Abbott's question. The legislature has established a public policy about workers' compensation and people who are non-subscribers. So we have to look there to see what it is to determine whether that's been violated.
That is correct. But if this court...
But we don't have any independent public policy that we can enforce to go your way.
If this court looks at the statute and determines the legislative public policy or the public policy set forth by the legislature in the enactment of this act is violated by these waivers, then it has the power to invalidate those.
I agree with that. What if we decide, because nothing said in there, say that it's okay if it's better or equals what workers' comp there's nothing, we think that's okay, so we don't think there's a violation of public policy. What other ground, if any, is there to say that the waiver is void?
Well, this court, for instance, going back to the Barnhart opinion back in 1918, but in that case, that was a non-workers' compensation case. The court said there's a non-delegable duty to provide a safe place to work for employees, and in that case, the employer asserted, or had the employee agree that the employer wouldn't be responsible for that. And what the Supreme Court said in that case is that the employee, or the employer rather, has a non-delegable duty to provide a safe place to work, and contracting around that violates the public policy in this state. So I think you can rely upon the public policy expressed in the statute, or you can rely upon other public policies such as was referred to in the Supreme Court in that case.
Any other questions? Thank you, counsel. The court is ready to hear argument from respondents.
May it please the court, Mr. Tom Morris and Mr. Luke Ashley will present argument for the respondents. Mr. Morris will open with the first 10 minutes.
May it please the court.
Mr. Morris, doesn't the legislature contemplate that with respect to safety in the workplace, that all employers of the state will either be subscribers for purposes of the workers' compensation law or non-subscribers and subject to provisions of the statute applicable to whichever choice they make?
The statute unquestionably provides for election for subscribers and non-subscribers. That is the policy of the Act, and any employer may either be a subscriber or a non-subscriber.
And it must be one or the other. It's a comprehensive scheme.
There's only two postures that an employer can have. He either subscribes to the Act or he does not.
And if he doesn't, I'm just trying to get an answer about how comprehensive the scheme is. If the employer chooses not to subscribe and then takes on non-subscriber status, then that employer is subject to the provisions of the Labor Code applicable to non-subscribers.
Those provisions which are applicable to non-subscribers, yes, and those are extremely limited, Your Honor.
Yes, but so it is a comprehensive scheme designed to cover all employers in the state.
Well, when you talk about designed to cover, the Compact is designed to cover, with respect to benefits, etc., those people who are non-subscribers are not prescribed or proscribed in either way.
I understand, but the point I'm trying to get to is how comprehensive is the legislative scheme? Is it designed to cover all employers in the state so that those who opt out are subject to certain legal requirements as set forth in the statute?
Only in some extremely limited cases,
situations. Is there a third category of employer?
There is.
Those who choose not to be a subscriber but are not subject to the non-subscriber applicable provisions of the statute?
There is no third classification. There's only two, subscribers and non-subscribers.
If we recognize then the validity of these waivers, are we not then creating a third category of employer? Those who choose to privately contract with their employees based on whatever terms they negotiate, if that is the appropriate term, with their employees.
They are still non-subscribers, and by virtue of being non-subscribers, they have the constitutional right to contract with their employees on a voluntary basis as they see fit, so long as they do not violate a provision of the Act or some other declared public policy.
I want to ask you about one of the specific provisions of the Act. One of the MECE cites a provision of the code that says if you're an employer, you can't buy employers' liability coverage unless you also buy workers' comp coverage.
Yes, 405, 256.A and Part B, the two parts of it.
What is your interpretation of what employers' liability coverage means?
Liability coverage is I cannot obtain an indemnity, and the statute says an indemnity. And an indemnity agreement is a precise type of agreement. And in particular, speaking of insurance, which will indemnify me for injuries to my employees, even though I am not a subscriber, and I can't buy that kind of insurance. The statute says I can't, unless the policy also provides workers' compensation.
Okay, so
So that's one of the things the Act prohibits, and a non-subscribing employer.
So to fund these private contractual agreements, the employer can't back that up with a policy from a recognized financially secure insurance company.
Absolutely not. The statute says he can't do that. He cannot buy indemnity agreements.
So the employee is stuck with looking at the financial viability of just the employer.
That's exactly where any employee of a non-subscriber is, whether he has a benefits plan or not. He's looking at the viability, financial viability of his employer to pay him if he gets hurt on the job, whether he be covered or not covered.
Let me ask you this. Does your case rise or fall on whether the benefits you offer are equal or better than?
That doesn't even touch my case, Your Honor, because that issue wasn't raised in my case. The Court of Appeals expressly said so. Under Rule 166 of the summary judgment rule, if you don't raise the point expressly in writing in the trial court, it's not available on appeal. It was not raised in the trial court expressly in writing in my case, and therefore comparability is not before me. I'm going to reserve that particular argument for Mr. Ashley because it isn't his case.
Well, then let me ask you this. Do you contend that an employer can get an employee to waive gross negligence?
Well, that's beside the point, Your Honor.
No.
It's not in this case. There's no gross negligence. There's no death case. No death in my case, so it's not in my case.
Hold a second. Because if we decide the case your way, we're going to be saying that it's either not a violation of public policy to have these waiver agreements, or it is a public policy issue that we want the legislature to decide. Bottom line is, with regard to these waiver agreements, these waiver letters that the employees enter into, they are waiving their rights against the company. And what I want to know is, do you contend that it would be permissible for these waiver agreements to include a waiver of gross negligence?
Well, we're running into a constitutional question there that's not before me in my case.
And what is that?
It's not before the court in this case. The right to recover for intentional injury or gross negligence in a death case is a constitutional provision. It's not provided by the Compact. The Compact merely preserves that right which is granted by the Texas Constitution, and from the beginning, 1886 or so, that was granted by the Constitution. So all the Compact has done is preserve that. Now, whether or not an employer can enter into an agreement which would violate that constitutional provision is not before me, it's not before this court.
But the language of these waivers that is before the court does waive all causes of action against the employer.
No question about it. That's absolutely correct.
So you're then taking the position that, in fact, there may be a problem with the waivers to the extent they purport to waive claims for gross negligence, but we just should reserve that for another day?
I'm not taking the position that there may be a problem. I'm saying that is a question that's not before this court in this case, in my case, on the record made in my case, and it's something that should be left to a future case when it's properly raised.
Well, but Mr. Heinrich says, though, that this contract, this waiver, violates public policy. And he is looking to the provisions of the statute that would allow an employee to sue a non-subscriber for common law negligence without the benefit of defenses related to the conduct of the employee. And the Compact also would preserve the right to sue for gross negligence. And that public policy is embodied in the statute. And he says that if we allow these waivers, that public policy would be violated. Why isn't he correct on that? Would you respond to that argument,
very
please?
quickly, Your Honor. Because the statute, the prohibitions in the statute of what an employer, a non-subscribing employer, cannot do are three. He cannot assert, excuse me, there are two sections. Under one section, 30.33, he cannot assert contributory negligence, which this court has now held, and Kroger is also comparative negligence. He cannot assert assumed risk, and he cannot assert full service. Now, that's the public policy which the legislature has invoked to try to get employers to subscribe.
If the legislature says you can't argue assumed risk,
absolutely.
Why wouldn't the legislature also mean by policy that you can't argue contractually assumed risk?
Well, if the legislature hasn't said so, it hasn't said that. And assumed risk is a tort doctrine. It's a tort doctrine. It's just like contributory negligence and felon servant are tort doctrines. What we're talking about here is an area of free contract, free right to contract, unless there be a statutory prohibition, and there isn't any.
Let me ask
And as
Ms.
this court
Morris.
has said so many times, over and over and over again, if there's a problem in the statute, the place to fix it is the legislature and not this court.
Mr. Morrissey, you say that the statute is very specific, that if you're a non-subscriber, you can't buy indemnity insurance.
That's what the statute said.
Now, indemnity insurance also has a provision on generally the right to defend. The insurance company has the right to take over the defense. Is that not a statement by the legislature that they don't want the employer to have alternate funding for a defense against their employees? So not only do they do away with some of the common law defenses, but they also attempt to provide the employer with the financial resources to defend against an employee that's suing them for negligence.
When you go right on to the next section of the statute, Your Honor, the very next section that prohibits that type of indemnity agreement authorizes the employer to obtain other types of insurance covering its employees, as is included in these plans, provided it does not purport to be workers' compensation. That's what the statute does.
But it does, the indication of lack of indemnity means that they don't want the employer, even if the employer is not a subscriber, they don't want the employer buying third-party liability insurance that necessarily implicates a vigorous defense against the claim of the employee.
Well, you could perhaps say by implication that is there, and may I beg the court's pardon, I've used my 10 minutes and I'm using all of Mr. Ashley's time, and I don't want to do that.
Any other questions, Mr. Morris?
I appreciate the appearance before this court.
Mr. Ashley, let me direct my question at you. Does your case rise or fall on the equality of the benefits provided?
No, it does not, Your Honor.
And why not?
Our position is that you could affirm on the basis that the benefit that affiliated provided, in this particular case to Mr. Lambert, and overall under the affiliated plan that, as I believe you pointed out, includes coverage for non-occupational as well as occupational injuries, that the overall benefits are better. And so that would satisfy the test that they proposed.
I think that makes your answer to my question yes, that your case does rise or fall on us finding that the benefits are equal or better than.
My case doesn't, no, you could affirm for that reason, but in my view, you would be affirming for the wrong reasons. You would be reaching the right result, but for the wrong reason.
Let me ask you as a practical matter how this works. Let's assume you have a normal employment agreement where there are employee benefits that are provided. They aren't labeled as workers' comp. An employee is injured on the job and they collect under their employee benefit plan, plus they collect workers' comp. In the normal case, would they get both? Wouldn't they get both their medical payments under their employer-provided insurance?
You mean if the employer was a subscriber to comp and in addition to that had a separate benefit plan?
No, I'm saying they're a non-subscriber, but they do provide insurance, health insurance, medical coverage. The employee sues under a common law cause of action for negligence, but they also get their medical coverage under their employer-provided medical plan. Now, normally they would get both, would they not? They would get their insurance benefits, plus they would get their common law recovery.
Possibly. I guess there's an issue as to whether the employer would be entitled to a credit in the common law action for the amounts that were paid under the benefit plan, but it's possible they could end up recovering under both.
So now we're saying that if you tag onto this agreement, an agreement that the employee waives their common law right of coverage, then the only thing they look to are these private medical benefits that the employer now has to fund. They can't do it out of insurance, but they're doing it personally. Is that what you're saying?
I'm not understanding.
Well, I'm trying to see what the difference is. The legislature seems to me to be trying to foreclose the type of arrangement that you're talking about.
The difference, it seems to me, is the legislature really hadn't said anything about this one way or the other. And as the point that Mr. Morris, I believe, made is that, and was made in some of the questions earlier, it seems to me if there were to be a decision as to what types of non-subscriber benefit plans are acceptable or unacceptable under state law, that the sensible and the appropriate body to make that determination is the legislature. My point that I do want to discuss briefly was one that was at least touched on.
Mr. Ashley, before you move on from that, the legislature has made a decision that it prefers for employers to opt to be subscribers because it imposes penalties under the statute on non-subscribers. Isn't that that's been well recognized by this court for a very long time, the public policy behind the comp statute. Are you in agreement with that?
No, not totally, Your Honor. Certainly, they place the non-subscribing employer at a disadvantage in the absence of a benefit plan.
Exactly. And so having done that, the public policy of the legislature is to encourage employers to be subscribers because of the protections provided to employees. So my question is the same as I asked Mr. Morris then. Aren't we now creating a third category of employer that is outside the legislative scheme that has been in place in Texas for close to 100 years now?
Now, I agree with Mr. Morris that the legislature, with respect to non-subscribers, they did create disadvantages concerning the tort defenses were available to you. They did not purport to restrict the right to contract under that statute.
But they tried to put the non-subscribers at a disadvantage financially and because of the risk to force the non-subscribers into the comp scheme. And if we recognize a third category, the right to contract outside, then aren't we undercutting the legislature's policy, and isn't everyone, as I believe the amicus brief said, aren't we going to see employers fleeing the scheme because now they can do their own independent arrangements entirely outside the comp scheme?
In my view, the decision the legislature made in 1989 when they rejected the recommendation of the Joint Committee to make comp mandatory is they allowed comp to compete with the non-subscriber alternatives. And the non-subscriber alternatives, Justice Heck referred to the Cook case, that included these benefit plans. And these benefit plans are ERISA plans, which are specifically established and permitted under federal law. So what the legislature actually did was they allowed the competition to continue between the workers' compensation system and the non-subscriber alternative, and that is what has been going on since then.
Does the ERISA put a floor on how minimal these plans can be?
ERISA does not, I'm not aware of any ERISA provisions that would regulate the content of these plans.
So you're saying a plan that offered virtually no benefit, as long as it was something more than a peppercorn, would not invoke any public policy consideration?
Well, what I'm saying is, first of all, that's not what's happened.
Well, I understand that, but we can't decide every case that comes along. This is the ones we have. You say public policy is not implicated if the plans under at least some view provide less benefits than comp. But is there a point at which it can get so low that public policy would be implicated?
Certainly, there are points at which you could get a plan that isn't defensible. And it would be, these employees have the opportunity, these are voluntary plans, the employees wouldn't accept a plan in those circumstances.
But let's say they did, and it ends up paying virtually nothing. Is public policy ever implicated by that?
Well, public policy may well be, Texas public policy may well be implicated by that plan, but in order to attempt to regulate that plan, you would be regulating the benefits that are available under ERISA plan, and if the legislature were to pass a statute, for example, that regulated set a certain minimum level of benefits.
I'm not interested. I'm interested under the current law, and I think it's yes or no. Could the benefits get so low that a worker could knowingly agree to sign up with this and then still sue after an injury on the grounds that the benefits were so low that public policy had been violated?
Unless the worker could successfully rescind the plan, rescind their participation for some reason, there wouldn't be anything currently. And my point really is that while that may be a potential problem, it doesn't seem to be a real one because of the way that the competition is actually developed between the non-subscriber alternatives and the workers' compensation.
What if you have a minimum wage worker who's offered a $10,000 sign-on bonus and up to $3,000 in benefits if you're injured or killed on the job in exchange for a waiver of all liability? Don't you think at some point those types of agreements put us right back where we were in 1913, and this is what the legislature was trying to
I agree.
get around.
I'm not trying to defend and not suggesting that a company should or ought to be permitted to make such an agreement. What I am suggesting is that Texas does not have the authority to pass a statute that would outlaw such a plan. If you look at the waiver, and the waiver is, and this is in the exhibits that I have included for oral argument, the waiver is part of an ERISA plan. One of the clearly, that is a contract between the employee and the plan, a separate legal entity.
You said
And
Texas didn't have the power to outlaw such a plan, apart from whether or not there's a conflict, even with a... But what I'm trying to get at, very inartfully, is 49 states require compensation mandatory.
They do have the power to do that. Absolutely do have the power to do that. They could change the decision that they made in 1989 and make comp mandatory.
But you claim that short of doing that, they have no power to have plans?
They have no power
to outlaw certain plans as being too...
They have no power to regulate the benefits under the plan. And the key to this is it is the waiver that determines the benefits that are available to the participant under the plan. This is illustrated in the Wolf case that the Dallas Court of Appeals decided on August 6th of this year. It was a two-tiered plan. And so the employee in that case got one level of benefits if they agreed to waive. They got a different and higher level of benefits if they didn't waive their right to bring a common law action against the employer under that plan. So it's absolutely clear that it is the waiver that is part of the benefit plan that is determining the level of benefits under the plan.
Mr. Ashley,
my point is that...
How many other states have allowed these waivers and how many have disallowed them?
Well, Your Honor, again, Texas is the only state that does not have mandatory comp at this point in time. So there were 3 states, and I'm not aware of, there were 3 states in 1989, and I'm not aware of any decisions in those states as to whether the waivers are valid or invalid.
You were just about to finish your sentence, so I wanted to hear your answer. You were finishing a response, or you were explaining that somehow you think this is preempted by ERISA.
Correct.
And would you finish that answer?
Well, I think it is preempted by ERISA if Texas, the Texas legislature were to attempt to pass a statute to regulate the provisions of the employee benefit plan. There's no preemption problem if the decision is that the waiver is not against public policy.
But the provision of the employee benefit plan in accordance with ERISA is a different question as to whether or not the employer requires a waiver of rights under our labor code.
The employer doesn't require a waiver. These are voluntary plans, and Mr. Lambert had the option. It was not a condition of his employment.
What would happen if you didn't sign?
He would remain at work. He would have his common law rights, and he would not receive...
How many employees were without benefits? How many employees elected to go that way?
There's nothing in the record about that, Your Honor, but I think the affiliated plan, virtually everybody participates because it's such a good plan.
Okay, Mr. Ashley, I've got a quick question for you. In response to one of my questions, Mr. Heinrich said that this plan does not meet the fair notice cases, the conspicuousness, and maybe I misread that. I thought there was an assertion that it did. In Texas, this court has discussed the exculpation clause, the waiver of the other party's negligence, and we have said that that's got to be conspicuous if that's going to happen, and if it's conspicuous, then that's not against public policy. I posed that question, and I was told, well, this doesn't pass the fair notice test. Can you respond to that?
My response is, Your Honor, that these individual issues concerning whether there was fair notice or whether there was sufficiently conspicuous, that is not raised by the petitioner in the Lambert case in this court. Those issues were raised below, and their position was rejected.
But that's not before us at this point.
No, Your Honor.
Any other questions? Thank you, counsel.
Also, one of the contentions is that it would be bad public policy to subject workers to these types of waiver agreements, and then have it turn out that when the worker is injured, the company doesn't have any assets to back it up and doesn't have any insurance to pay for it. Is that not the same situation that a worker would be in with an employer that is a non-subscriber?
If the employer doesn't take the insurance or can't get the insurance, I guess it would always be the same. I'm sorry.
If an employer is a non-subscriber
Yes, sir.
and provides no benefits, and the worker has as his only resort suing the company for negligence,
Yes, sir.
and it turns out that the company doesn't have any assets
Yes.
to cover the claim,
Yes.
how is that different than your claim that allowing waivers would be horrible because companies wouldn't have any money to pay for workers?
I don't think in that instance that it turns out differently. I think that what the Workers' Compensation Act was saying, we want you to subscribe, because if you do subscribe, then you will have this protection. There's a liability policy behind if they're insolvent, then that problem is resolved.
But of course, they don't have to subscribe.
No, they do not have to subscribe, but there is this penalty that's placed upon them for doing that. If a company is insolvent and it doesn't take insurance, and that's the way that it's treated its employees, then yes, they're in a comparable situation.
And companies could go belly up, and the worker who works for a non-subscribing employer may get nothing if that worker is injured, correct?
Correct.
And so, help me understand the meaningfulness of the argument that it would be inappropriate to allow these waiver agreements because these waiver agreements can't be backed up by an employer who has insurance company, and therefore the employer may not be able to pay the employee.
Well, I think the point is that if you allow these waivers, that they can offer any type of a benefits package whatsoever. They do not have to back it up by insurance, that you will not even have that cause of action against them. They are protected, I guess, by some scenario other than taking out comp. You want to promote them to take out comp. You want to say that you're a subscriber or non-subscriber. We want to make it to your advantage to take out comp. And if you don't, then we're not going to give you a separate level of protection that says, all you're going to get out of here is $1 a day, because that's what you agreed under this waiver. We're not insolvent because all we've got to pay you is $1 a day.
How is the employee benefited? If the employer can make the election to be a non-subscriber, leaving the employee to have to prove the employer's negligence to get a recovery in a work-related injury, the defense is being set aside. I understand that, but you still got to have your primary case you've got to prove. How does that benefit the employee to prevent the employee from contracting for no-fault coverage with the employer? How is the employee benefited by prohibiting the employee who works for a non-subscriber from entering into an agreement with the employer for no-fault benefits?
Well, I don't think that the worker is specifically benefited by that. But I think what the intent of the policy of setting that in the statute, the legislature, was to say, we want you to be naked. We want you as an employer that you know that if you've got assets out here, that it's going to be your assets that are going to be attacked. It's not going to be some insurance companies that's going to be on the hook for you. And so they say, unless you're dealing with the small company that's insolvent and already it doesn't have any assets, if you're dealing with a company the size of Affiliated, then you're telling them that you're the one that's on the hook if you don't go into comp. And that's the reason.
That goes to the extent that we will prohibit the employee who works for a non-subscriber from trying to work out a better deal. They either have to go straight negligence, lawsuits, that sort of thing, or they have to just work for an employer that's a subscriber.
Well, there's some definite case law out there that talks about that early on, that's the decision of the employees to do that. But I think that when you come down to it and you say, we got to make it a policy decision, and the legislature made that policy decision that says, what can we do? That's exactly where they came down, was they said, we're going to make these people be subscribers, and if they aren't subscribers, then they're not going to be able to take the other route and be advantaged. And I know there's some disadvantages to that for the worker, perhaps, but we're trying to get those people to be subscribers. I know that my time is up, but I just wanted to say.
Does anybody want to hear their conclusion? What do you want to say?
that it was not clear from original argument that we made two different arguments here. That first, and Justice O'Neill, that's why I'm trying to address this, is that the Act itself does prohibit it regardless of whatever the benefits are. That's also been our argument. And not only because of the fact that as Justice Hankinson was talking about, that you get to elect one of those two, that you're either a subscriber or you're subject to that suit, which is statutorily said that's going to be there, but also within that statute, 406033, it talks about assumption of the risk and that you cannot put that risk on your employee. And back a long time ago, when this court and the United States Supreme Court talked about the Workers' Compensation Act, they talked about how the Act itself was a division of risk.
Let me ask you this about assuming the risk. Let's assume that in this waiver agreement, the employer says, I will guarantee you payment of everything to the penny of what the Workers' Compensation Act allows, plus an additional $250,000 per claim.
Yes, sir.
Would that waiver agreement be unlawful or against public policy?
I think so. Okay, now let me explain that.
So they get everything plus an extra $250,000.
That's different from what you're.
That's different. But it could go both ways. You could go both ways on that. Okay, if you read the Act specifically and it says that you cannot cannot have them assume the risk, and you view the Comp Act itself as a division of the risk. Well, what that statute says is that you cannot put any risk on your employee. You can't put any of it on.
Would there be any risk on the employee if the employee got more under the waiver agreement than the employee would get under a comp agreement?
Well, sure. I mean, there's risk. There's minimal risk. But if he's got all of this covered up and he lost $1 million because he couldn't do something else, so the $250,000 didn't cover, well, he had some risk. Yes, it's minimal at that point in time. And yes, maybe what you can say is that if you get to that level to where you guaranteed the comp benefits, and that ought to be the test. It's not apples and oranges. It's did you cover the comp requirements? That should be the test. But if you did cover those comp requirements, then you could say no harm, no foul. The benefits, the quid pro quo that the Texas government prescribed under workers' compensation, that you got those benefits. So what's the public policy against it? You could take that approach, but the statute itself says, and I think this is what they intended from the very beginning, was that we're going to make this division of risk if you're a subscriber, but if you're a non-subscriber, you cannot put an iota of risk on your employer. That's what it says, and that's what it means when it says assuming risk. This court has been so good in the past at defending that. In the Sears case where they said, oh, it's a no-duty doctrine over here, it's really not assumption of risk, it's whether they're negligent at all. And y'all said, no, that puts risk on the employee. And in the recent Kroger case, it wasn't statutory. There's no statutory thing there, but you upheld it because it said contributory risk, and you understood where the purpose of that statute was. And I think that's your goal. That's your purpose here. And if you believe that the legislature has said this is what the division is, then it's just your job to enforce that and say that's what it says.
Do you think maybe the
means.
legislature was as silent as it has been because of ERISA?
I do not know, and I've not considered that. I do not believe in any way that your judgments here are preempted by ERISA whatsoever. You have total power to determine whether this statute is valid or not valid. Perhaps because ERISA was out there that they may not.
Do you think they were worried that if they said that you can't include in an employee benefit plan a waiver of common law liability that they would have run afoul of ERISA. Do you think that's maybe why they didn't say that?
Don't know, but I think it's addressed already in the statute. That's my firm belief, is that with the assumption of risk in all the cases, if y'all will look at the cases where it says assume risk throughout the history of y'all's decisions, you will see that what I'm talking about is correct, that they say you cannot make them assume the risk. And maybe that's why they didn't address it that way. But it's still in the statute already.
Any other
It's not
questions?
necessary.
Thank you, counsel.
Thank you, Your Honor, very much.
That concludes today's arguments at South Texas College of Law. The court will now be in recess, and there will be a reception later that will see some of you out, I hope. The marshal, our clerk, John Adams, will now adjourn this session.
Please rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned. Please remain in place until the court has departed.